constitutional lawyer. I've been a litigator and a lawyer for 38 years, practicing in the highest levels of the federal courts. My concern here is as a lawyer and as a litigator. And I think this bill is misnamed. The bill is really not the Firearms Safety Act of 2013. It's the legal nightmare for Penalties Act of 2013. This bill is rife with legal traps for the unwary. And it's almost designed to be a situation where persons who are caught up in this, otherwise law-abiding citizens who obey the law as a matter of course every day, are caught up in a situation where they simply don't know that they're violating the law. And the penalties are so severe that the loss of their liberty, but also the loss of every firearm they have, regardless of whether or not they are in fact actually put into jail. And I'll give you one example, which is near and dear to my heart. I have a 19-year-old son. He is legally able to purchase a long gun in this state, under both federal and state law. The shotgun and the hunting rifle, he hunts with it. He's an excellent and very safe hunter. Under this bill, he is legally prohibited from possessing a single round of any type of ammunition. A .22 rimfire, a shotgun shell, doesn't matter. And the bill does this through a surreptitious amendment to 5-133D by deleting the portion of the bill that restricts the age restriction to ammunition designed solely for regulated firearms, and then adds 5-133.1 to broadly define firearms, and then ban the possession of firearms for all persons who may not possess regulated firearms. And if you look back at 5-133, you will see that one of those bans is on persons under the age of 21. Now, I have submitted written testimonies, 12 pages, single space. I commend it to you. It details all of this in painful detail. It's a legal brief, if you will. But this would bar my son, who in 2 years will graduate from VMI and probably be commissioned as a second lieutenant Marine, from possessing a single round of ammunition when he comes home from school. It will bar him from hunting. It will bar him from trap shooting, target practice. He will be able to actually purchase a long gun, but the moment he takes possession of ammunition for that very legal long gun that he possesses, he will be subject to a year in prison. That's not right. And the list goes on and on as to other legal traps for the unwary.
I know you want to tell us what you got, but...
I understand, and I thank you for your time.
Oh, you've got some people...
Oh, good. I would like to answer questions.
Thank you very much, and I have read your testimony, and I'm still trying to wrap my head around this provision, so I'm going to need a little bit more help on that.
You bet.
So, anyway, but towards that issue, let me move to something, because for a variety of reasons that we've heard today, and some that we'll hear later, I am very concerned about this aspect of the otherwise law-abiding citizen who you just referred to, who's going to get caught up in this. And I think this committee has genuinely been concerned about that in a variety of different issues. And the fact that there is no mens rea in here is deeply concerning to me. Is there a fix to that provision? If we were to say knowingly and willingly violate the provisions of that, is there anything that can fix that, in your opinion, within the confines of this bill?
The ban on ammunition possession by a person under 21, I don't see how there is a fix. You don't need it, for one. You have existing law under 5-133D2 that says that an under 21-year-old may not possess ammunition designed solely for regulated firearms. Why do you need to ban any possession of ammunition? The center requirement that we're referring to just raises the disputed issue of fact. It's not going to protect him from arrest. If my son is arrested, there goes his Marine commission. It doesn't matter if he's convicted.
It's just the arrest itself.
Just the arrest will do that. He will be forced to defend himself in court, attorney's fees and costs, not to mention the legal problem that goes with that. You have a similar situation with the registration requirements, 30-day window. On the 31st day, you're a criminal. Doesn't matter if you You simply didn't know. There's no provision for a late registration. If you have that, you may have been out of this town, you may have been out of the country, you may have been on wherever. It's an innocent failure to register criminal. 3 years in jail. And because it's in excess of 2 years, you automatically employed, upon conviction, a federal firearms disability under 18 U.S.C. 922G. All his firearms are gone for an innocent failure to register a so-called assault weapon. That's insane to me.
So towards that point, I agree with most of what you have said and most of what the opponents of the bill have said. But moving forward in terms of looking at within the confines of this bill, again, I hear you in saying you can't put knowingly, willingly in. What is a reasonable balance in terms of if the committee is to move forward on any type of registration, which I don't know whether we would or not, do you make it a civil fine? I mean, obviously the state has the ability, and should have the ability to say, okay, we want you to do X, Y, and Z, and if you don't, there's going to be consequences for it. Is there something in here that is more acceptable, or again, it's just the whole thing?
So are you talking about the ammunition ban?
I'm talking about the ammunition ban, I'm talking about the failure to register if it's a handgun, and then I'm talking about the other criminal provision which I've caught in here, which is the failure to register the so-called assault weapon.
Well, and there's other provisions too, if you read my legal brief, if you will. The requirement of intent requirement is really not going to fix the problem. It's simply the police officer is going to look at it and say, well, you're intending what you're doing, so you're under arrest. So that's the interim effect that will keep the people basically under the thumb trying to go, keep me. And I know the law. And I'm not taking any chances with that. I have a security clearance. If I'm arrested, I lose my security clearance. What you have to figure out is whether or not what you're doing here is addressing the problem at hand, which is the illegal use of handguns, not by law-abiding citizens. Now, I've heard testimony today about, for example, that you need the registration period for a prior registration period and licensing of handgun owners. Now, I own handguns. I own several. Because you need to stop straw purchases. Well, as a matter of constitutional law, that is a burden. This licensing provision, all of that, including the hundreds of dollars of cost and perhaps months of delay, is a direct burden on the constitutional right to purchase the handgun. You're going to have to justify that in court, and you're not entitled to a rational basis test on this. You're going to have to do at least intermediate scrutiny, which means you're going to have to show with actual evidence that this registration, this prior licensing provision, will in fact meet the problem you're saying it's going to meet. Conjecture's not going to cut it. The idea that a straw purchaser, to me, it doesn't make any sense. So a person who's willing to fill out Form 77 and Form 4473, federal and state forms under penalty of perjury with felony penalties associated with them, would be the slightest bit deterred from doing the same straw purchaser by having to go to the state police barracks and having a fingerprint. They don't care. Criminals don't care. And that is the point. They're going to do a straw purchase, they will do it regardless. But what you're doing in the process of trying to stop a straw purchase that you can't even be sure that it's going to be stopped is you're going to be substantially burdened with high costs and long delays, the very fundamental right that Heller affirmed to every citizen in this room. And
I think we have another question with Senator Jacobs, if you don't mind.
yes, I'm sorry.
Oh, that's okay. Earlier when I mentioned to the governor's people that I would become a criminal if I did not go back and register my firearms before October 31st. They said that was not true.
Oh, you would?
I know I would.
You
I
would
have
indeed.
Attorney General's opinion here that says I would. So on October 31st, everybody in this room who owns a firearm, if they don't get their butts down there and register them, they're criminals.
That's a regulated firearm, Senator.
I'm sorry.
But yes,
My
in
assault
fact,
weapon.
if your so-called assault weapon, I mean,
Yes.
a rifle, if you will, the rifle that hardly causes any crime, you would indeed, because there's no provision in this bill that allows you to register on the 31st day. Because on that 31st day, the mere possession of that rifle, and there's a no intent requirement, becomes a criminal act, punishable by 3 years in prison. the very provision that used to apply only to assault pistols, a very narrow class, has now been expanded to guns that were legally purchased, legally possessed, and legally used up to that 31st day. That's wrong. You are criminalizing people who are tax-paying, productive citizens who live their life in accordance with law. It penalizes everyone. And I don't even own an assault weapon, but it's still wrong.
So cool.